Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's video, we are going to discuss Bharatiya Sakshya Adhiniyam 2023, section 146 to section 161, that is question to witnesses.
And today we're going to tackle a really important topic from the Indian Evidence Act, Section 146, which is all about so-called leading questions.
So, how are we going to break this down? Well, we've got a clear plan. First, we'll cover the basics. What even is a leading question? Then, we'll get into the nitty-gritty, the core legal parts of the section. After that, we'll see how it actually works in court, look at its status in the new laws, and finally, we'll wrap up with what's most important for you: exam focus and revision.
All right, let's jump right into our first section, understanding the basics. So what exactly is a leading question? And, why is it such a big deal in the eyes of the law? Okay, so we're talking about Section 146 of the Indian Evidence Act 1872. Now, why should you care? Well, for anyone preparing for judiciary or APO exams, this section is absolutely crucial. Think of it as the backbone of how witnesses are questioned. Its main goal? To make sure the entire process of recording evidence is fundamentally fair.
Let's look at what the law actually says. The BEAR Act defines it like this: any question suggesting the answer which the person putting it wishes or expects to receive is called a leading question. In simple words, it's any question that already has the answer hidden inside it. The question itself is guiding the witness. This is restricted because, let's be honest, it could easily influence testimony or even create memories that aren't real.
Okay, so we know what a leading question is. Now let's move on to our second section and really deconstruct the law. We're going to break down Section 146 into its core components to see how it all works in practice.
So, there are a few key ingredients here. First, and most obviously, the question has to suggest the answer. That's the whole point. Second, let's talk about examination in chief. Here, you generally can't ask them, especially if the other side objects. You'll need the court's permission. But, and this is a big but, during cross-examination, it's a completely different story. They are totally allowed. And finally, remember the court's discretion. The judge can always permit them for simple things like introductory facts that nobody is arguing about. This flowchart is a great way to visualize how a judge thinks about this. It's like a mental checklist. So, step 1, a lawyer asks a question. Step 2, the judge thinks, does this question suggest the answer? If yes, then boom, it's a leading question. Step 3, then the judge considers the context. Are we in examination in chief or cross-examination? And that leads to the final decision in step 4. Is this question permitted or not?
All right, enough with the theory for a moment. Let's get practical. How does this all play out in a real courtroom? This is where it gets really interesting. Take a look at this. It's a perfect example. On one side, we have the leading question. You were at the scene at 10 p.m., correct? See how it feeds the information, the place, the time to the witness? All they have to do is say yes or no. Now look at the other side, the non-leading question. Where were you at 10 p.m.? This is completely open-ended. It doesn't suggest anything and lets the witness tell their own story.
So let's see this in action. Imagine you're in an examination in chief. The lawyer can't just ask their own witness, the accused hit the victim, right? Nope, that's too suggestive. Instead, they have to ask something open, like, what happened next? But flip the scenario. Now it's cross-examination. The opposing lawyer can absolutely ask, you did not see the accused at the spot, correct? They're trying to challenge the testimony, so it's allowed.
Okay, let's talk about a really important case. State of Rajasthan versus Kashi Ram. What did the court say here? They emphasized something super important. For a trial to be fair, a witness's testimony has to be recorded without any kind of undue influence. This principle directly connects to why we have these restrictions on leading questions in examination in chief.
And here's another key case for you. State of Uttar Pradesh versus M.K. Anthony. This one focuses on the other side of the coin, cross-examination. The court basically said that leading questions are a crucial tool for testing if a witness is telling the truth. It's how you check their credibility. And that's exactly why they are so freely allowed at that stage.
Okay, we've seen how it works in practice. Now let's look at the bigger picture. Where does this section stand today, especially with all the new laws coming into effect?
This is a big one for your exams. The provision we've been talking about, Section 146 of the old Indian Evidence Act, has been carried over. In the new Bharatiya Sakshya Adhiniyam of 2023, you'll find it under a new number, Section 140. So please, make sure you know both, the old number and the new one. It's super important.
Here's a key distinction to remember. Section 146 is what we call a rule of procedure. What does that mean? It means it's all about how to do things in court, specifically how to question witnesses. It's not defining a crime, and there's no punishment attached to it. It's all about the process, not the offense itself.
All right, let's get to the part you've been waiting for. This is where we focus on what you absolutely need to know for your judiciary and APO exams. Let's consolidate everything with a solid revision. Okay, exam tips. For your prelims, be ready for a direct question. They might just ask for the section number or the definition. Pretty straightforward. For mains, it gets a bit trickier. You could see a short note or even a problem-based question testing its application. And the absolute key concept, the one thing you must remember, is the clear distinction between its use in examination in chief versus cross-examination.
So, to boil it all down for a super quick revision, just remember these key points. The section is 146 of the Indian Evidence Act. The core concept is a question that suggests the answer. And the key rule is its different application in chief and cross-examination. And its importance for both prelims and mains is very, very high.
And that's a wrap on Section 146. I really hope this detailed explainer was helpful for your preparation. For more judiciary, APO, and law exam-focused legal content, make sure you stay connected with us right here at Ganga Education.
All right, let's get started. Today, we're diving into a really important topic, Section 147 of the Bharatiya Sakshya Adhiniyam 2023. Now, this section is all about evidence as to matters in writing. And let me tell you, it's absolutely crucial for anyone preparing for the judiciary and APO exams. So let's break it down.
So, picture this. You're in a courtroom. A witness gets up and starts describing what's in a contract, but they don't have the contract with them. Can they do that? Can they just talk about a written document without actually showing it? That single question, well, that's the heart of what Section 147 is all about. And we're going to find out the answer right now. Okay, so here's our game plan for this explainer. We'll start with a quick intro to Section 147, then we'll get into the nitty-gritty and deconstruct the BEAR Act itself. After that, we'll see how it actually works in a courtroom. We'll also look at some key judicial precedents, the big cases. And finally, we'll wrap up with some tips focused specifically on your exams. All right, let's start with the basics. To really understand Section 147, you first have to grasp a fundamental legal principle. It's called the best evidence rule.
So, what is the best evidence rule? Well, it's actually pretty simple. It says that if you want to prove what a document says, the best way to do that is, you guessed it, the document itself, the original. You can't just have someone talk about it instead. And why is this so important? Well, it's all about ensuring authenticity and stopping people from misrepresenting what was actually written down. Okay, now that we have the background, let's roll up our sleeves and look at the actual legal text. We're going to break down the language of the BEAR Act piece by piece.
This right here, this is the key. The adverse party, that's the other side, can actually object to someone giving oral evidence about a document's contents until that document is physically produced in court. It's a powerful tool.
So to put it plainly, if a witness is on this stand talking about a contract or a will or a sale deed, the other lawyer can stand up and say, "Objection, show us the document first." It's as simple as that.
Now let's zoom in on a few key words you really need to know from this section. First up, contract, grant, disposition. This is just a catch-all for pretty much any matter that's been put into a written document. Next, adverse party may object. This is huge. It gives the opposing side the legal right to challenge the testimony. Then we have until document is produced. This means the objection stands strong until the original document is shown to the court. And finally, there's an exception, secondary evidence. This is only allowed if you can prove the original document is unavailable for a valid reason.
Okay, theory is great, but let's get practical. How does this whole thing actually play out in a real courtroom? Let's see it in action.
Let's imagine a classic property dispute. You have a witness on the stand and they confidently state, "That land was transferred to me. It's mine. I have a sale deed." Okay, so watch what happens next. The other lawyer hears sale deed. That's a written document. They'll ask, "So, this transfer was in writing?"
The witness says, yes, in a sale deed. And bam, that's the moment. The opposing lawyer will jump up, object, and cite Section 147 demanding, Your Honor, the witness must produce the sale deed. See? That's the section in action. It's a real-time check on the evidence.
But, like with many things in law, there's a really important exception to this rule. Let's look at an example straight from the Act. Imagine a witness says, I heard person A say that person B wrote him a threatening letter, and because of that, he was going to get revenge. Now, you might think, wait, where's the letter? But this is allowed. Why? Because the point here isn't to prove what the letter said. The point is to prove person A's motive, the reason they wanted revenge. It's about their state of mind, not the document's contents.
Of course, the law is shaped by court decisions. So, let's look at a few landmark judgments that have really cemented how Section 147 is interpreted.
And this quote from the Supreme Court just says it all, doesn't it? Oral evidence cannot be substituted for the document. It's so clear, so direct. The highest court in the land has made it crystal clear. You can't just talk about a document when the real thing is available. This is a foundational precedent. A key case you absolutely need to know is Rup Kumar versus Mohan Thadani. The big question before the court was, can someone give oral evidence about what's in a written contract? The Supreme Court's answer was a firm no. They held that once the terms of a contract are written down, that document becomes the one and only evidence of those terms. This really reinforces the whole idea of documentary evidence being supreme.
Another important case that builds on this is Site Taraji Kimchand versus Yelamarti Satyam. This case laid out the procedure really clearly. It said you have two options to prove a document's contents. Option 1, the best option, is to produce the original. That's called primary evidence. Option 2, if the original is gone, you have to prove it's gone, and then you can submit copies. That's secondary evidence. What's not an option? Just talking about it. That's not enough.
You know, there's a classic Latin maxim that perfectly captures the idea behind all this. Verba volant, scripta manet. It translates to spoken words fly away, written words remain. It's a fantastic way to remember the whole point of Section 147. What's written down stays. All right, let's shift gears and focus on what you're all here for, the exams. How is this section going to show up on your judiciary and APO papers? Let's talk strategy.
Okay, for your prelims, be ready for direct questions. They might ask you the section number, or they might ask about the best evidence rule. Simple recall. Now for the mains, it gets more interesting. You're very likely to see a problem-based question, just like that property dispute scenario we walked through. You could also get a short note question, maybe on a topic like documentary supremacy. And if you get that, you absolutely have to cite Section 147.
So, for a last-minute quick revision, just lock in these three things. 1. The section number is 147. 2. The core concept is the best evidence rule. And 3. The main takeaway is that this section is all about the supremacy of written documents over spoken testimony. Got it? 147, best evidence rule, documentary supremacy.
So there you have it. Section 147 is the muscle that enforces the best evidence rule, making sure our courts rely on authentic and accurate written evidence. I hope this breakdown was helpful for you. For more legal explainers focused on your judiciary, APO, and law exam preparation, make sure you stay connected with us here at Ganga Education.
And today we are going to tackle a really important topic for your exams, Section 148 of the new Bharatiya Sakshya Adhiniyam 2023. So picture this. You've seen it 1,000 times in movies and TV shows, right? A witness is on the stand under oath, and they suddenly say something that completely contradicts what they said earlier. They just changed their story. So what's a lawyer supposed to do? What's the right way to handle that? Well, the answer to that exact problem is what we're talking about today, and it's all laid out in Section 148. All right, here's our game plan for today. We'll start with the basic rule in Section 148. Then we'll break it down into its essential parts. After that, we'll walk through the exact procedure for contradiction, look at some key legal principles and cases, compare the new law to the old one, and wrap it all up with some must-know takeaways for your exams. Okay, let's get right into it with our first topic, the rule. We need to understand the heart of Section 148, what it's all about, and how it governs the use of previous written statements during a cross-examination. Now, let's be crystal clear about this, and please pay close attention. We are talking about Section 148 of the Bharatiya Sakshya Adhiniyam 2023. This is the new law. It has replaced the old Indian Evidence Act. In your exams, you absolutely cannot make the mistake of writing the old act's name or a wrong section number. So remember, Section 148 BSA 2023. And this section deals specifically with cross-examining a witness about things they've said before in writing. So let's look at the actual text from the law. In simple terms, you can think of this section as having two parts. Part 1 says you can ask a witness about a previous written statement without even showing them the paper, just to test their memory. But, and this is the crucial part, if your main goal is to contradict the witness, to prove they are lying or mistaken, then you have to follow a very specific rule. You can't just surprise them. All right, let's break this rule down into its essential ingredients. Understanding these key components is absolutely vital if you want to apply this section correctly, especially in a problem-based exam question. The whole section really stands on 4 pillars. First, you need a previous statement in writing. It can't be something they just said, it has to be written down. Second, that statement has to be relevant to the matter. It has to actually be about the case. Third, you can start the cross-examination without showing them the document. But it's the 4th ingredient, the contradiction requirement, that's the real heart of the rule. The law says you must draw the witness's attention to the exact part of the statement you're using to contradict them. So, how does this all play out in a real courtroom? What are the actual steps you have to take to legally contradict a witness? Let's walk through the procedure that every lawyer has to follow. It's a clear 4-step process. Step 1. You can ask general questions about the statement without showing it to them. Step 2. But the moment you want to contradict them, you must show them the document and point to the specific sentence or part you're talking about. Step 3. You have to give them a chance to explain themselves. Maybe there's a good reason for the difference. And step 4. Only after you've done all that can you actually prove that written statement in court to show the contradiction. And here's a perfect example of how this works. Let's say a witness testifies in court, "I saw the accused, A, at 10 p.m. But in their statement to the police right after the incident, they wrote, "I did not see A." Now, the lawyer can't just stand up and say, "Aha, you're lying. Here's your police statement." Nope. They must first show that written statement to the witness, point to the line, and ask them about it. This gives the witness a fair chance to respond before the contradiction can be officially entered as evidence. This is a classic exam scenario, by the way. This step-by-step procedure isn't just a random technical rule. It's actually backed by some very strong legal principles and landmark Supreme Court judgments. Let's take a look at the legal foundation that gives this section its real power. The one case you absolutely have to remember here is Tahsildar Singh versus State of UP. This is the landmark judgment. In this case, the Supreme Court made it incredibly clear. They held that if you want to challenge a witness's credibility using a past statement, you are required to first draw their attention to those specific contradictory parts. The court said this isn't optional, it's a mandatory rule to ensure basic fairness. And this whole procedure, this entire idea of fairness, is rooted in a fundamental principle of our legal system, a legal maxim called audi alterum partem. It literally means hear the other side. And why is this so important? Well, it prevents what we might call a trial by ambush. It ensures that a witness isn't just blindsided and discredited unfairly. They get a fair shot to explain any inconsistency. This is really the bedrock of a fair trial. Okay, let's quickly touch on the legislative change. As you all know, we have new criminal laws now. So how does this section connect to the old Evidence Act that we all studied? So the old law was the Indian Evidence Act of 1872. That's now been replaced by the Bharatiya Sakshya Adhiniyam 2023. Here's the most important thing for you to remember. The core legal principle hasn't changed at all. The rule is exactly the same. The only thing that has changed is the address, you could say. The provision is now located in Section 148 of the BSA 2023. Don't mix them up.
All right, let's wrap this all up and focus on what really matters for your judiciary and APO exams. Think of this as your quick and dirty revision guide.
When you're preparing, keep an eye out for 3 kinds of questions on this topic. In your prelims, you'll probably get a direct question about the procedural rule in Section 148. For your mains, you should definitely expect a problem-based question, just like the scenario we discussed. And you could also be asked to write a short note on the principle of fair cross-examination under this section. So for that last-minute revision, just lock these 3 things in your mind. 1. The section number is 148 of the BSA 2023. Say it again, 148 BSA. 2. The core concept is you must show the witness the statement before you can contradict them with it. And 3, the key principle behind it all is audi alterum partem, the rule of fairness. I really hope this breakdown of Section 148 was helpful. As you continue your studies, just think about how this simple procedural rule perfectly balances the need to challenge evidence with the fundamental right to a fair hearing. It's a beautiful part of our justice system. For more deep dives like this, make sure you stay connected with us here at Ganga Education.
Now, have you ever wondered how lawyers can ask those really tough personal questions in court? Well, this section is the reason why. It deals with the power of cross-examination and, just as importantly, its limits. For your judiciary and APO exams, understanding this balance is absolutely crucial. So let's get started.
Here's our game plan for this explainer. We'll start by building a strong foundation, really understanding Section 149. Then, we're going to break it down into its key legal parts. After that, we'll see how it actually works in court with some practical examples, and finally, we'll wrap up with a sharp focus on how to master this topic for your upcoming exams.
All right, let's dive right into our first part, building a solid understanding of Section 149.
So, Section 149 is found in the chapter about the examination of witnesses. And, it's all about a critical balance. On one hand, it gives lawyers a pretty wide runway to question a witness. But on the other, it puts up some really important guardrails to protect witnesses from harassment. Mastering this legal tightrope walk is exactly what you need to do for your exams.
Let's look at what the law actually says. A witness can be questioned to test his veracity, yani to check if they're being truthful, and to shake his credit, which means you can question their character to challenge how reliable they are. In simple terms, think of this as the lawyer's toolkit. It gives them the power to dig deep and ask the court to consider, is this witness really telling the truth? And more than that, can we even trust what they're saying?
Okay, now that we have the big picture, let's zoom in on the details. We're going to break this section down into its essential legal ingredients to see how it all works.
You'll find there are 4 key ideas you absolutely need to remember here. First up is test veracity. That's all about fact-checking the witness's story. Second, discover position in life, which is about understanding their background to see if there's any potential bias. Third, we have shake credit. This lets a lawyer challenge the witness's credibility as a whole. And last, but incredibly important, is the proviso. This is a special rule that acts as a shield, protecting victims in sexual offense cases.
So, how does a court actually use this section? Well, this flowchart here lays it out perfectly. A lawyer asks questions with 3 main goals in mind: testing truthfulness, uncovering any bias, and challenging the witness's reliability. When you put the answers to all these questions together, it helps the court make a final judgment on the overall credibility of the witness and their testimony. It's a very systematic process for getting to the truth.
All right, theory is great, but how does Section 149 actually play out in a real courtroom? Let's get practical and see how this law comes to life during a trial.
To make this concept really stick, let's walk through a few practical examples, the kind of scenarios you might actually see in a problem-based question on your exam.
Okay, let's break these down. For testing veracity, imagine a witness says they saw the crime. The lawyer might ask, what color were the walls, or how many windows were in the room? If the answers don't add up, their story starts to fall apart. For background questions, a lawyer could ask, isn't it true that you were the accused's business partner? This reveals a potential bias. To shake credit, a question about a witness's past conviction for, say, cheating might be allowed. But here's the really important part, the restriction. In a rape case, the defense lawyer is absolutely forbidden from asking the victim about her past sexual experiences. This protection is non-negotiable.
And this leads us perfectly into the landmark judgment of State of Punjab versus Gurmeet Singh. In this incredibly important case, the Supreme Court came down very strongly on the need to protect the dignity of rape victims. The court ruled that cross-examination cannot be allowed to become a tool for harassment. It restricted irrelevant, character-assassinating questions, reinforcing the very spirit of the proviso in Section 149. This case is a must-know.
This whole idea of testing truthfulness is captured by a famous legal maxim, falsus in uno, falsus in omnis. It basically means false in one thing, false in everything. So, if a lawyer can prove a witness lied about even a small detail, they can argue that the witness's entire testimony should be thrown out. Now, it's important to remember that Indian courts use this principle very, very cautiously. They won't automatically dismiss everything a witness says.
Okay, let's switch gears and get to what matters most for all of you who are preparing for exams. How is this section tested and what's the best way to revise it?
Now, here's something you really need to be aware of, the link to our new laws. That crucial proviso in Section 149 of the Evidence Act, the one that protects victims, well, it's now connected to the new definitions of sexual offenses under the Bharatiya Sakshya Adhiniyam, the BNS 2023. The fundamental principle of protecting the victim's dignity is carried forward completely, which means this section is as relevant as ever. So what kind of questions should you actually be preparing for in your judiciary and APO exams? Let me give you some specific tips.
For your prelims, be on the lookout for a direct question, like, what is the primary purpose of Section 149, or something about the proviso. For the mains exam, you could definitely get a short note on lawful questions in cross-examination. But I think the most challenging and common type of question is a problem-based one. They'll give you a courtroom scenario and ask you to decide if a specific question asked by a lawyer is legally permissible under Section 149.
All right, let's boil it all down for a quick revision. If you're going to remember just 3 things from our discussion today, make it these. First, the section number, 149 of the Indian Evidence Act. Second, the core concept. It allows wide-ranging questions to test the credibility of a witness. And third, its most critical feature, the proviso that shields victims of sexual offenses from questions about their past. And remember, its importance for both prelims and mains is extremely high.
And that's a wrap on our deep dive into Section 149. I really hope this structured breakdown helps you feel more confident in your preparation. For more exam-focused legal content for judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Today, we're going to break down Section 151 of the Bharatiya Sakshya Adhiniyam, 2023. This is a really crucial section that deals with the court's power to control the cross-examination of witnesses, a must-know topic for your judiciary and APO exams. So let's get right into it.
So, we all know that the whole point of a cross-examination is to get to the truth. But you have to wonder, where does the law draw the line? Can a lawyer just ask anything they want? Is it okay to attack a witness's character just to make their testimony look bad? Well, Section 151 gives us the clear answers to these very important questions.
Here's what we've got lined up for today. We'll start with the court's power to protect a witness. Then we'll decode Section 151 itself, look at what a judge considers, and see how it works in a real courtroom. We'll also touch on some landmark judgments and finish up with the essentials you need for your exams.
All right, so let's get right into the main problem here. It's really a balancing act. On one side, you have the lawyer's right to cross-examine a witness. That's a cornerstone of our justice system to test if someone is telling the truth. But on the other side, you have to protect the witness's dignity and make sure they're not being harassed. So how does the law find a balance between these two things?
The answer is Section 151. Think of this section as a shield that safeguards the witness. It gives the judge discretionary power, so they can act like a referee in the courtroom, deciding when a lawyer has crossed the line. The key phrase to remember here is judicial discretion.
Let's look at what the law actually says. In simple terms, here's what it means. If a lawyer asks a question that isn't directly related to the case, and its only purpose is to damage the witness's character to make them seem less believable, the court gets to decide if the witness has to answer it or not.
To really get a handle on this section, we need to break it down into its essential ingredients. These are basically the tools that a judge uses to make a fair and effective decision right there in the courtroom.
First up, a question not directly relevant. This is a question about the witness's character, not the actual facts of the case. Second, judicial discretion, which we just talked about, is the court's power to decide. Third is the protection of the witness. The court can step in and tell the witness, you don't have to answer that. And fourth, this is a big one, adverse inference. If the court says a question is fair, but the witness refuses to answer, the court can assume the answer would have been bad for them.
So, you might be wondering, how does a judge actually make this decision? Is it just their own gut feeling? Not at all. The law is very clear about this. Section 151 gives the judge a specific checklist they have to follow.
Let's walk through the judge's mental checklist, step by step. First, the court asks, is the question proper? In other words, if what the lawyer is implying is true, would it seriously make the court doubt the witness's credibility? Step 2, is the question improper because it's too remote? For example, is it about something that happened ages ago and doesn't matter now? Step 3 is all about proportionality. The court weighs the importance of the attack on the witness's character against the importance of their evidence. Is it a fair trade-off? And finally, step 4 is the consequence. If a question passes all these checks and the witness still won't answer, the court can draw that adverse inference.
Okay, enough with the theory, right? Let's see how this actually works in a real courtroom. This kind of example will make the concept crystal clear, and it's especially helpful for those problem-based questions you get in your mains exam.
So, let's imagine a scenario. We're in a property dispute, and one witness's testimony is the key to the whole case. The defense lawyer knows this, so they start asking questions to attack the witness's character, trying to make them look dishonest in front of the judge.
Now, this slide really shows you the difference in action. Look at the first question. Did you cheat in college 20 years ago? This is improper. It's way too remote, right? It has no real bearing on whether the witness is truthful today. The court would probably disallow it. But the second question, were you convicted in a fraud case last year? That's a proper question. It directly and seriously impacts the witness's credibility right now. If the witness refuses to answer that, the court is well within its rights to draw an adverse inference.
You know, the BEAR Act gives you the rules, but it's the landmark judgments that really bring the law to life. Case law is so important because it shows us how courts have actually interpreted and applied these rules over the years. Knowing the leading cases is absolutely vital.
A really important case you need to know is State of Punjab versus Gurmeet Singh. In this case, the Supreme Court made it crystal clear that the court has a duty, not just a power, but a duty to protect witnesses from humiliating and irrelevant questions. This judgment really reinforces the whole spirit behind Section 151, which is all about protecting a witness's dignity.
And this whole idea connects perfectly to a famous legal maxim, audi alterum partem, which simply means listen to the other side. You see, a fair trial isn't just about hearing from both parties. It's also about making sure their witnesses can give testimony without being harassed or intimidated. So, witness protection is a basic part of a fair judicial process.
Okay, let's get to the part you've all been waiting for. How is this topic going to show up on your exams? Let's focus on exactly what you need to remember.
Okay, first things first, and this is super important. Please take a note of this. The rules that used to be in Section 148 of the old Indian Evidence Act 1872 are now in Section 151 of the new Bharatiya Sakshya Adhiniyam 2023. This is a classic question for your prelims, so don't get it wrong.
Let's talk about that key term again, adverse inference. It's really important to understand that this isn't a penalty or a fine. It's a legal presumption. When the court decides a question is proper and the witness refuses to answer, the court is allowed to legally assume that the answer would have been unfavorable to that witness. That's a very serious procedural consequence.
So for your exams, here's exactly what you need to focus on. For the prelims, expect a direct question on the section number, Section 151, or its main idea, which is judicial discretion. For your mains, you could get a short note on the court's power to control cross-examination, or a problem-based question where you have to apply Section 151. And in your interview, be ready to discuss that delicate balance between a witness's rights and the right to cross-examination.
All right, let's wrap this up with a super quick revision. If you remember nothing else, remember these points. 1. The section is 151 of the BSA. 2. Its core concept is the court's discretionary power to protect witnesses. 3. The key principle is all about balancing the right to cross-examine with the witness's dignity. And 4. The consequence can either be a warning to the witness or drawing an adverse inference. The big takeaway here is that Section 151 is like the guardian of fairness in the courtroom. It makes sure that the search for truth doesn't destroy human dignity.
And that's a wrap on Section 151. We really hope you found this breakdown useful. For more legal content focused specifically on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Today, we're diving into a really important provision for witness protection, and that's Section 152 of the Bharatiya Sakshya Adhiniyam 2023. Now listen closely. Make sure you get the name of this new act and the section number right because it has replaced the old evidence law. This section is all about protecting the dignity of a witness during cross-examination. So, what's our game plan for today? We'll break down Section 152 into 4 simple parts. First, we'll look at its foundation. Then, we're going to deconstruct the rule itself. After that, we'll see how it actually works in court. And finally, we'll get into a quick view specifically for your exams. Ready? Let's go.
All right, let's start with part 1, the foundation. You see, at its heart, Section 152 is like a shield. It's an ethical and procedural safeguard right inside the courtroom that makes sure cross-examination is fair and, just as importantly, respectful.
And what is it protecting against? Well, this slide gets right to the point. The court has the power to stop any questions that are just baseless, scandalous, or designed to defame someone. So if a question is only meant to attack a witness's character without any real substance behind it, it's just not allowed. Simple as that.
Now let's move on to our second section, where we're going to deconstruct the rule itself. This is where we get into the nitty-gritty, looking at the exact words of the law to see what makes it tick.
So the BEAR Act reads just like this. Now, what does all that legal jargon actually mean? Well, it's pretty straightforward, actually. Any question that attacks a person's character, which is what Section 151 talks about, should not be asked unless, and this is the key part, unless the lawyer has reasonable grounds to believe that the accusation is actually true.
We can actually break this down into 3 essential ingredients. First up, character imputation. This just means the question is a direct hit on the witness's credibility or character. Second, reasonable grounds. This is huge. It means the question can't be based on a random guess, it has to come from credible information. And third, advocate's responsibility. This puts the duty squarely on the lawyer to check their facts before they ask a damaging question.
So how does the court actually enforce this? It's like a 4-step process. Step 1, a lawyer asks a question that attacks the witness's character. Step 2, the judge steps in and assesses, does the lawyer have reasonable grounds? Step 3, if the grounds are there, okay, the question is allowed. But step 4, if there are no solid grounds, the question is shut down. The court literally acts as a gatekeeper.
All right, that brings us to our third segment, application in court. Theory is one thing, but now let's see how this rule actually plays out in real courtroom scenarios with some practical examples and landmark cases.
Let's look at 2 totally different situations to make this crystal clear. Scenario 1. An advocate has bank documents that strongly suggest a witness was involved in fraud. In this case, asking about the fraud is totally permissible. Why? Because there are reasonable grounds. Now, scenario 2. An advocate just randomly asks a witness, "Are you a thief?" with zero proof. That is absolutely not allowed. It's a baseless attack. And you know, the courts have been very clear on this. The case of State of Punjab versus Gurmit Singh is a perfect example. The Supreme Court laid it down in no uncertain terms. Witnesses cannot be harassed or have their character assassinated just for the sake of cross-examination. This judgment really captures the spirit of Section 152. This whole idea is also beautifully reflected in a classic legal maxim, actor incumbent onus probendi. What does that mean? It means the burden of proof is on the person who makes the claim. So, if a lawyer is going to make a serious allegation against a witness, the burden is on them to show that they have reasonable grounds for it.
Okay, everyone, let's switch gears and focus on our final section, which I know is super important for all you judiciary and APO aspirants out there, the exam quick view. Let's talk about how this section can show up in your papers. For your prelims, you should definitely expect some direct questions. They might ask you about the section number itself or about its core concept, which is, you guessed it, reasonable grounds. Now for the mains, you should be ready for a short note on Section 152 or maybe a problem-based question where they give you a scenario and you have to decide if a question is allowed under this rule.
So, before we wrap up, let's do a lightning-fast revision. 3 key things to lock into your memory. 1. The section is 152 of the Bharatiya Sakshya Adhiniyam 2023. 2. The core concept is that questions attacking character require reasonable grounds. And 3. Its exam importance is high. This is a must-know rule. And that's our deep dive into Section 152, a really vital rule that balances the power of cross-examination with a person's fundamental right to dignity. For more legal content focused on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Today, we're going to break down a really crucial legal section, one that every single law student and judicial aspirant absolutely needs to know inside and out.
All right, let's jump right in with a situation I'm sure you can picture. Imagine you're in a courtroom, a cross-examination is going on, and a lawyer just keeps asking questions that have nothing to do with the case. You know, questions that are clearly just there to annoy or harass the witness. So what happens then? What can the court actually do about it? Is there any real consequence for that kind of behavior?
Well, the answer is right there in the law itself. Section 153 of the Bharatiya Sakshya Adhiniyam 2023. This is the specific provision that deals with exactly this kind of situation.
So, today we're going to dive deep into Section 153 of the Bharatiya Sakshya Adhiniyam 2023. And please, pay very close attention here. This is part of the new law. The old Indian Evidence Act is gone. It's been replaced. So it is absolutely critical that you don't make a mistake with the section numbers. For your judiciary and APO exams, this section is incredibly important because it's directly linked to professional ethics and courtroom procedure.
Now, let's look at the actual language from the BEAR Act. It says that if the court believes a question was asked without reasonable grounds, it has the power to report the situation to the High Court or another authority. In simple terms, what this means is that the section gives the court a tool, a real power, to report the conduct of irresponsible advocates.
Okay, to really get a grip on this section, we need to break it down into its core ingredients. Just like any legal provision, there are a few essential elements that you have to understand to see how it works.
Let's take a look at this table. First up, we have question without reasonable grounds. This just means questions that have no real basis in fact. Second, the opinion of the court. This is crucial. The court itself has to be satisfied that the question was improper. Third, this whole rule applies specifically when the person asking the question is an advocate. And fourth, and this is a really key point, it's a discretionary power. The law uses the word may, which tells us that the court isn't forced to report it, it's their choice, their discretion.
So here's the thing. This section doesn't just lay down a rule. It actually establishes a whole procedure. Let's walk through the practical, step-by-step process that a court would follow in this situation.
You'll see the procedure is actually pretty straightforward. Step 1. An advocate asks a baseless question during cross-examination. Step 2. The court forms an official opinion that the question was, in fact, improper. And finally, Step 3. If the court decides to act, it can report the advocate's conduct to a higher authority, like the High Court or the Bar Council. And from there, that advocate could face professional misconduct proceedings.
Okay, so we've got the theory down, but theory is one thing, right? What does this actually look like in practice? Let's try to understand it better with a few real-world courtroom examples.
This really highlights the difference perfectly. For instance, if an advocate makes a baseless accusation about a witness's character with zero evidence to back it up, that's actionable. Or if a question is asked only to insult or harass the witness, that's also actionable. But, and this is a very important distinction, if an advocate asks a tough question based on information they believe is true, even if they can't prove it later, that's considered good faith. In that case, no action would be taken.
All right, now let's talk about some landmark case laws. As you know, these are incredibly important for your exams. The first big one we need to look at is R.K. Anand versus the Delhi High Court.
In this case, the Supreme Court really zeroed in on the ethical conduct of advocates. The court made it crystal clear that lawyers are expected to maintain the highest professional standards during judicial proceedings. This ruling seriously reinforced the principle of professional accountability, which is, you guessed it, the very core idea behind Section 153.
Okay, let's move on to our next key precedent, which builds on this idea. This one is the state of Punjab versus Gurmit Singh.
Now, this case deals directly with the protection of witnesses. The court held that it is the duty of the court to protect witnesses from harassment and improper questioning. So you can see how Section 153 fits in. It provides the court with the exact tool it needs to carry out that duty, ensuring the witness's dignity is maintained and the trial remains fair.
There's also an important legal maxim connected to this section, actus curiae neminem grabobat. It's a fancy way of saying that an act of the court should not prejudice anyone. So, when a court uses its power under Section 153 to report an advocate, it's not acting against one of the parties in the case. Instead, it's acting to uphold the entire integrity of the entire justice system. So when you take a step back, what is the overall purpose here? Why does a section like this matter so much in the grand scheme of things?
Well, this section plays a whole bunch of important rules. First, it acts as a powerful deterrent against irresponsible cross-examination. It helps ensure discipline and proper decorum in the courtroom. It protects the dignity of the witness, which is so important. It promotes ethical advocacy and high professional standards. And perhaps most importantly, it upholds the fundamental principle of a fair trial.
Okay, now let's get to what might be the most important part for many of you, the part related directly to your exams. How should you prepare this section for your judiciary and APO exams? For your prelims, you could get a direct question on the section number itself. So remember, Section 153, Bharatiya Sakshya Adhiniyam 2023. For mains, you might see a short note on it or maybe a problem-based question where you have to analyze a scenario and decide if an advocate's conduct falls under Section 153. And in the interview, be ready to discuss the broader topic of professional ethics for advocates and why it's so important.
All right, let's do a super quick revision. If you remember nothing else, remember these three things. 1. The section is Section 153 of the Bharatiya Sakshya Adhiniyam 2023. 2. The core concept is the court's discretionary power to report an advocate's misconduct. And 3. Its key purpose is to maintain professional accountability and protect the dignity of the witness.
And that's a wrap for this explainer. I really hope that Section 153 is perfectly clear to you now. For more detailed legal content like this, designed specifically for your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Today, we're tackling a really important section, one that acts like a guardian of dignity inside the courtroom. We're talking about Section 154 of the brand new Bharatiya Sakshya Adhiniyam 2023. This one deals with indecent and scandalous questions. Now, if you're preparing for your judiciary or APO exams, let me tell you, understanding this section is absolutely crucial. So let's dive right in. So here's our game plan. We'll start with a quick intro to the section, break down its key parts, see how it works in a real courtroom, compare the new law with the old one, and then wrap up with some solid tips for your exams.
All right, let's get started. We're looking at Chapter 10, which is all about the examination of witnesses. And right there, we have Section 154 of the Bharatiya Sakshya Adhiniyam 2023. Now listen up, this is super important. This is the new act, so please make no mistake with the section number. It's 154 now.
So what does this section actually do? Well, its main job is to give power to the court. It's like handing the judge a remote control to manage the questions being asked during a witness examination. It acts as a shield, you know? It protects witnesses from having to answer indecent, offensive, or downright scandalous questions. It's a fundamental rule that helps maintain the dignity of the entire court proceeding.
Okay, now let's get into the nitty-gritty. We're going to break down the legal text and really understand its core ingredients. I mean, what does the law actually mean when it says indecent or scandalous?
The BEAR Act says pretty clearly that the court can forbid any question or inquiry that it thinks is indecent or scandalous. But, and this is a big but, there's a crucial exception. If that question is directly related to the facts in issue, the main points of the case, then it might be allowed. To put it simply, the court won't stop questions that are necessary for justice, but it will absolutely put a stop to questions that are just there to harass a witness.
So, let's break this down into 4 T parts. First up, indecent or scandalous. This basically means any question whose only purpose is to annoy or insult the witness. Second, discretion of court. This is huge. It's up to the judge's wisdom to decide whether a question is okay or not. Third, we have the exception. Remember, if a question is directly connected to the facts in issue, it can be asked. And finally, witness dignity. This is the whole point, right? The ultimate goal is to protect witnesses from being harassed or humiliated on the stand.
So how does a judge actually use this power in the moment? Well, you can think of it as a simple 3-step mental checklist. First, the judge assesses the question. Is this indecent or scandalous? Step 2, they check for that exception. Does this relate to a fact and issue? Is it really necessary? And finally, step 3, they make the call. If the question is improper and the exception doesn't fit, boom, the question is forbidden.
All right, enough with the theory. Let's move on to how this plays out in real-life courtroom scenarios, from the books to the bench.
Just imagine this for a second. You're in a trial. A lawyer starts asking a witness some really personal questions, stuff that has absolutely nothing to do with the case. Their only goal is clearly to embarrass the witness. That's the exact moment when Section 154 is supposed to kick in. So what kind of questions can the court shut down? Well, for one, questions about a witness's private life that are totally irrelevant to the case. Another big one is questions designed purely to attack a victim's character or morality, something we unfortunately see a lot in sexual offense cases. And third, any irrelevant and scandalous allegations thrown around just to assassinate someone's character. The court can put a stop to all of that.
And this isn't just a rule on paper. The Supreme Court has backed this principle time and time again. This quote really hammers home the point that it's the court's duty to shield victims from these kinds of indecent and humiliating questions.
If we look at some landmark judgments, like State of Punjab versus Gurmeet Singh, the Supreme Court was very clear. Courts have a duty to protect victims, especially in sensitive cases, from a humiliating cross-examination. Similarly, in the Bodhisattva Gautam versus Subra Chakraborty case, the court recognized just how fundamentally important it is to protect the dignity of women during any kind of judicial proceeding.
You can even connect this idea to the famous legal maxim audi alterum partem, which means let the other side be heard. Now, in this context, it takes on a slightly different flavor. It implies that a truly fair procedure isn't just about hearing someone out, it's also about protecting them from undue humiliation while they're being heard.
Okay, let's talk about something that is super important, especially from an exam point of view. What's the difference between the new Bharatiya Sakshya Adhiniyam 2023 and the old Indian Evidence Act of 1872 when it comes to this rule?
Now, this is a key change you absolutely have to remember. In the old Indian Evidence Act, we had 2 sections for this. Section 151 for indecent and scandalous questions, and Section 152 for questions intended to insult or annoy. The new Bharatiya Sakshya Adhiniyam 2023 has streamlined this. It takes the principles from both of those old sections and consolidates them into a single powerful section, Section 154. So for this topic, the only number you need to remember now is 154.
Let's clear up a common point of confusion. Is there any punishment under this section? The short answer is no. Section 154 is a rule of procedure. It doesn't create a substantive offense. That means there's no specific punishment attached to it. It's all about governing how things are done inside the courtroom.
All right, let's get to our final segment and focus on exactly what you need to know for your judiciary and APO exams.
So, why does this section matter so much? What's its real value? Think of it this way. It's a protective shield for witnesses. It stops harassment and character assassination dead in its tracks. It makes sure there's decency and order in the court. And most importantly, it strikes that critical balance between the search for truth and respecting basic human dignity.
Here's a pro tip for your exams. For prelims, you can definitely expect a direct, section-based question. They might just ask you what Section 154 is about. For mains, you need to be ready for a bit more. Prepare for a short note on it, or even a problem-based question, where they give you a courtroom scenario and you have to apply the rule.
Okay, time for a super quick revision. Just lock these 3 things in your mind. 1. The section number is 154 of the Bharatiya Sakshya Adhiniyam 2023. 2. The core concept is the court's power to forbid indecent questions to protect a witness's dignity. And 3. The key exception is when the question relates to a fact in issue. And remember, this is a high importance topic for both prelims and mains.
And to leave you with something to think about, a little food for thought. In today's digital world, where anything said in open court can go viral in minutes, how can our courts apply Section 154 to protect witnesses from the online harassment that might follow? It's a modern problem for sure. Think about it.
For more legal content focused specifically on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Today, we're tackling 2 really important sections from the brand new Bharatiya Sakshya Adhiniyam 2023. We're looking at sections 155 and 156. Now, if you're gearing up for your judiciary or APO exams, trust me, you need to know these rules inside and out. They're all about witness examination, and they are crucial. So, you ready? Let's get right into it.
So, here's what we've got on the agenda. First, we'll touch on the big idea here, why we even need to protect witnesses in the first place. Then, we'll get into the nitty-gritty of Section 155, and then Section 156. After we've got the theory down, we'll see how it all works in the real world with some practical scenarios. And, this is super important, we'll compare the old law with the new one. Finally, I'll wrap it up with some quick exam tips to help you lock in this knowledge.
You know, at the end of the day, a trial is all about one thing, getting to the truth. But how we get there matters, right? It's not a free-for-all. It's just as important to make sure the courtroom remains a place of dignity, and that witnesses, who are there to help, don't end up being harassed or humiliated. That's where Sections 155 and 156 come in. Think of them as the guardrails that keep the trial on track, balancing the search for truth with basic human respect.
Okay, let's jump into our first section, Section 155. I like to call this one the dignity shield, and that's exactly what it is, a shield for the witness. Its whole job is to protect them from questions that are just designed to insult or annoy them, especially during a tough cross-examination. It's all about keeping the process civil and respectful.
So let's take a look at the actual text from the BEAR Act. It says the court shall forbid any question that seems intended to insult or annoy. And there's a second part to this, which is really interesting. Even if a question is technically proper, if it's asked in a way that's, needlessly offensive, the court has to step in and shut it down. So it's not just about what you ask, but also how you ask it.
Let's break this down even further. You've got 2 main things the court looks for. First, the intent. Is the lawyer asking this just to humiliate the witness? Second, the form. Is the question okay, but the tone or wording is just plain offensive? And here's the absolute key takeaway. The law says the court shall forbid it. That shall is everything. It's not a suggestion, it's a command. It's a mandatory duty for the judge, who has the final say on whether a question crosses that line.
And this isn't just some abstract rule, The courts have backed this up time and time again. Look at these cases. In state of Punjab versus Gurmeet Singh, for example, the Supreme Court really drove home this point about protecting witnesses from being humiliated on the stand. So these landmark judgments give real teeth to Section 155. They make it crystal clear that a witness's dignity is non-negotiable, particularly in very sensitive cases.
All right, now let's switch gears to Section 156. This one is often called the rule of finality, and its main goal, efficiency. Think about it. A trial could go on forever if lawyers were allowed to argue about every little side issue. So this section puts a stop to that. It basically limits your ability to bring in new evidence just to contradict a witness on questions that are only about their character, not about the actual facts of the case.
So what does that actually mean? Let's make it simple. Imagine you ask a witness a question that's just meant to shake their credibility, something about their past character, and they answer it. That's it. You're generally stuck with their answer. For instance, if you ask, "Weren't you fired from your last job for dishonesty?" and they say no, you can't then start a mini-trial to prove they were. The law says, for the purpose of that credibility question, their answer is final. We have to move on.
But, and this is a huge but, especially for your exams, while the general rule is no contradiction, there are two major exceptions. This is where the law shows its cleverness. First exception, if you ask a witness if they've been previously convicted of a crime and they lie and say no, you are allowed to bring in evidence to prove they were. Second exception, if a witness denies being biased, like say they deny being the defendant's business partner, you are allowed to bring in evidence to prove that bias. These two are game changers.
So to sum it up, the question has to be about credibility, not the core facts. The whole point of the rule is to stop the court from going down endless rabbit holes on side issues. And we've covered the two big exceptions, previous conviction and bias. Now, one last thing. Does this mean a witness can just lie without any consequences? Not at all. They might not be contradicted in that moment, but they can absolutely face a separate criminal charge for perjury, for giving false evidence.
And again, the judiciary has weighed in heavily on this. Landmark cases like Tehsildar Singh versus State of UP have really helped to draw the line in the sand. The courts have consistently said, yes, we need to test a witness's credibility, but we can't let it become a free-for-all. Section 156 provides those essential boundaries.
Okay, enough theory. Let's get practical. We're going to look at a few courtroom scenarios to really nail down the difference between Section 155 and 156. This is exactly the kind of stuff they'll ask you about in your mains exam, so pay close attention. Let's walk through this table together. Look at the first one. The lawyer asks, "You're a known liar, aren't you?" in a really abusive way. What happens? The judge steps in. That's Section 155 in action. It's about the insulting form of the question. Now, scenario 2, the question is, did you commit fraud in 2010? And the witness says no. The question is allowed, but can the lawyer bring in proof? No. That's Section 156's general rule. But now look at the third one. Isn't the accused your business rival? The witness denies it. Ah, this hits one of our exceptions, bias. So here, the question is allowed, and you can bring in evidence to prove they are rivals. See the difference?
Okay, now for what might be the single most important part of this entire discussion, especially for all you exam aspirants. Listen very carefully. We have new laws now. This means you cannot, under any circumstances, get the old and new section numbers mixed up. It's such an easy mistake to make, and it can cost you dearly.
All right, look at this slide. Burn it into your memory. What used to be Section 151 of the old Indian Evidence Act is now Section 155 of the Bharatiya Sakshya Adhiniyam 2023. And the old Section 153 is now Section 156. Please, I'm telling you, do not write the old numbers in your exam paper. You have to write Bharatiya Sakshya Adhiniyam and the new section numbers. Get this wrong and you're just throwing marks away. Simple as that.
All right, let's bring it all home with some targeted tips to help you ace any question on this topic in your exams. Let's make sure all this information translates into marks.
So for your prelims, you're probably going to see direct questions, like which section deals with insulting questions. Easy marks if you know the number. For your mains, it's going to get trickier. They'll give you a problem, a scenario, and you'll have to figure out if it's a 155 issue or a 156 issue. Just remember this simple rule. Section 155 is about the form, how the question is asked. Section 156 is about the substance, what happens after the answer is given. And I'll say it again, those two exceptions under 156, examiners love them, know them cold.
Okay, one last super quick revision. Look at this table. Section 155, think dignity shield. It's about protecting the witness. Your exam keyword is form of the question. Section 156, think finality rule. It's about trial efficiency. Your exam keywords are the two exceptions, conviction and bias. Go ahead, take a screenshot. This is your perfect cheat sheet for the last few minutes before the exam.
So as we wrap up, I want to leave you with something to think about. How do these two sections, Section 155 and 156, really perform that delicate balancing act? On one hand, you have the court's mission to find the absolute truth. On the other, you have the fundamental need to treat every person with dignity. It's a tough balance to strike, and these sections are right at the heart of it.
And that's a wrap on sections 155 and 156. I really hope this detailed breakdown helps you in your preparation. For more deep dives into legal topics that are crucial for your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Today, we're going to break down a really important legal provision, and that is Section 157 of the brand new Bharatiya Sakshya Adhiniyam 2023. Now, this section deals with a very tricky situation called a hostile witness. Trust me, this is a hot topic for your judiciary and APO exams, so let's get right into it. So picture this. You're in court. You've brought a witness to support your case, someone you're counting on. But then, right there on the stand, they completely flip and start speaking against you. What do? This isn't just drama for the movies. It's a real and serious problem in our justice system. So, what do we call such a witness? Well, the legal term is a hostile witness. To put it simply, this is someone who gives one statement to the police during the investigation, but when they get to court, they change their story. Or, they might just show a clear prejudice against the very side that called them to testify. So here's our game plan for today. First, we'll dig into why hostile witnesses are such a big problem. Then we'll look at the solution, Section 157 of the BSA. We'll see how it's used in court, check out some key case laws, talk about the bigger picture, and then of course we'll wrap up with a quick revision just for your exams. Okay, let's start with our first topic. Before we can really appreciate the legal fix, we first need to understand the problem itself. Why is a witness turning hostile such a major roadblock for justice? You might be wondering, why would a witness suddenly change their tune? Well, there are a bunch of reasons. Sometimes it's pretty direct, like threats or intimidation from the accused party. Or, let's be honest, sometimes it's just plain old bribery. But there are also bigger systemic problems at play, like the fact that we don't have a strong witness protection system, or that trials can drag on forever, and sometimes witnesses are just treated poorly in court. So to tackle this issue, the law gives us a specific tool. Now, this is where I need you to listen very carefully, especially for your exams. We are talking about Section 157 of the new Bharatiya Sakshya Adhiniyam 2023. Please do not make the mistake of writing about the old Indian Evidence Act. Okay, so let's look at the actual text. Subsection 1 is where the power lies. In simple English, it says that the judge has the discretion, the power, to allow the party who called the witness to ask questions as if they were the opposing lawyer. It basically lets you cross-examine your own witness. But wait, there's a crucial part too. Subsection 2 clarifies something very important. Just because the witness has been declared hostile and you're cross-examining them, it doesn't mean their entire testimony gets thrown in the trash. You can still pick and choose to rely on any part of their evidence that actually helps your case. Let's break this down even further with these key words. First, court's discretion. This is key. It's not an automatic right. The judge has to agree to it. Second, questions like cross-examination. This means you can ask leading questions, the kind designed to get a yes or no answer, to try and get to the truth. And third, reliable evidence, which we just talked about. You can still use the good parts of their statement. Okay, so we've got the theory down. But what does this look like in a real courtroom? Let's walk through the practical application. This flowchart makes it super simple to follow. It starts at step 1. You call your witness. Step 2, the witness goes hostile, maybe contradicting what they told the police. That's your cue for step 3. You ask the court for permission. If the judge agrees, that's step 4. And finally, in step 5, you get to cross-examine your own witness. It's a clear, logical process. All right, everyone, pens and highlighters out. This slide is a guaranteed exam point. So let's be crystal clear. The old law was Section 154 of the Indian Evidence Act 1872. The new law is Section 157 of the Bharatiya Sakshya Adhiniyam 2023. Please, please, please do not get these two mixed up in your answer sheets. It's a common mistake and you need to avoid it. Just reading the bare act is never enough, right? To really understand the law and write those high-scoring answers in your mains, you have to know how the courts have interpreted it. And for that, we need to look at landmark case laws. When it comes to hostile witnesses, the one case you absolutely must know is Satpal versus Delhi administration. The big question here was, what do we do with the evidence of a hostile witness? Is it all useless?
The Supreme Court gave a very clear answer. No, the testimony should not be thrown out completely. The court can and should accept any part of it that seems credible and reliable. And this principle is based on a beautiful judicial philosophy. There's a Latin maxim, falsus in one, falsus in omnibus, which means false in one thing, false in everything. But in India, our courts don't follow this strictly. Instead, the court's job is seen as separating the wheat from the chaff, or in this case, the truth from the lie. So to quickly summarize the evidentiary value, what are the key takeaways? Number 1, the evidence is not thrown out. Number 2, the court can accept the parts it trusts. Number 3, it will reject the parts that are unreliable. And the whole point of this exercise is to find the truth and test just how credible the witness really is. Now, while Section 157 is a very useful tool for a lawyer, it's really just treating a symptom, not the disease. The problem of hostile witnesses points to much deeper systemic challenges. So let's broaden the discussion and talk about the root causes and potential reforms. A really powerful, real-world example of this whole mess is the Jessica Lal murder case. I'm sure many of you remember it. It was a case where several key witnesses turned hostile one by one, and it led to the accused being acquitted at first. That verdict sent shockwaves across the country and really shone a spotlight on just how broken the system was when it came to protecting witnesses. So what can be done? Well, the Malamath Committee, which looked into reforming our criminal justice system, had some great suggestions. Things like holding trials in camera to reduce pressure, protecting a witness's identity, and most importantly, creating a strong national law for witness protection. Even simple things like providing better security and treating witnesses with respect in court can make a huge difference. All right, let's bring it all home now with the part I know you've been waiting for. Let's do a quick, super focused revision of everything we've just learned, tailored specifically for your exams. Okay, listen up. For your prelims, be ready for a direct question on Section 157 of the BSA. Simple as that. But for your mains, it'll get more complex. You can expect a problem-based question where you have to apply this section, or a short note asking you to explain the evidentiary value of a hostile witness's testimony. So prepare for both. Here it is, all on one slide for a quick screenshot. This section is 157 of BSA, 2023. The core concept is the court's power to let you cross-examine your own witness. The key principle, coming from the case law, is that the testimony isn't thrown out completely. And its importance for your exam? Extremely high. And I'll leave you with this final thought to chew on. If the whole point of a trial is to find the truth, then isn't having a strong, effective witness protection law maybe even more important than any single rule of evidence like this one? It's something worth thinking about. I hope this detailed explainer has cleared things up for you. For more content just like this, focused on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Today, we are diving deep into a really important part of the new Bharatiya Sakshya Adhiniyam 2023. We're talking about Section 160, which deals with impeaching a witness's credit. Trust me, this is a section you absolutely have to know for your judiciary and APO exams. So just imagine for a second, you're in a courtroom and a witness takes the stand. But as they're speaking, it's pretty clear they're not telling the truth. What do? How can you legally show the judge that this person's testimony just can't be trusted? Well, that's exactly where Section 160 comes into play. Think of it as the legal tool that our justice system gives you to formally challenge the credibility of a witness who might be dishonest or just plain unreliable. And this section is so important because it's really all about ensuring a fair trial. The whole point is to make sure that a court's decision isn't based on testimony that's biased, or even worse, completely false. It's about getting to the truth. Okay, so what does the law actually say? Let's pull back the curtain and break down the exact wording from the BEAR Act to see how this whole thing is structured. So what does all that legal jargon actually mean in plain English? It's pretty simple, really. It means a witness's believability can be challenged by two different people. First, by the adverse party, which is just the lawyer on the other side. And second, sometimes even the party that called the witness can challenge them, but only if they get the court's permission first. So let's quickly unpack these key phrases. When you hear impeach credit, it literally just means to challenge how truthful and reliable that witness is. The adverse party is simply the opposition in the case. And with consent of court is a really big deal. It means you can't just turn on your own witness. You have to get the judge's okay, which usually happens if your witness suddenly becomes hostile and starts hurting your case. Now, Section 160 doesn't just say, go ahead and challenge the witness. Nope. It's very specific. It lays out 3 distinct grounds or methods that you can use to do it. Let's take a look at what they are. Here are the 3 tools in your legal toolkit. First, you can actually bring other people to the stand who can testify that, yeah, they know this witness, and this person has a reputation for not being trustworthy. Second, you can show the court hard proof that the witness was bribed or offered something to testify in a certain way. And third, you can point out that what the witness is saying now completely contradicts something they said before. Okay, theory is one thing, but to make this crystal clear, let's walk through a few practical, real-world examples you might actually see in a courtroom. So for that first method, character evidence, imagine a lawyer calling neighbors or colleagues of the witness to the stand, and they all say, yeah, in our community, this person is known for not telling the truth. For the second one, bribery, picture this. The lawyer presents bank records or a recording that shows the witness got a big chunk of money right before they agreed to testify. And for the third one, contradictory statement, which is super common, you show that the detailed statement the witness gave to the police is totally different from the story they're telling the court now. All right, now let's talk about something that's a huge deal for your exams, case law. How have the Supreme Court and our high courts actually applied this section? Let's find out. When you think of this section, you absolutely have to remember this case, Satpal versus Delhi Administration. It is the landmark judgment on this topic, and its principles are fundamental to understanding how all this works in practice. So the court established a really important rule here. It said that just because one part of a witness's testimony is proven to be false, it doesn't mean the judge has to throw out everything they said. The court has the power to sift through it all, keep what seems true, and discard what's false. You might have heard of this as the principle of separating the grain from the chaff. It's a huge concept. Okay, everyone, listen up. This next part is absolutely critical, and it's where a lot of people are going to make mistakes in their exams. We need to be crystal clear on the difference between the old law and the new law. Please pay very, very close attention here. This whole concept of impeaching a witness's credit used to be in Section 155 of the old Indian Evidence Act of 1872. That is gone. Now, under the new Bharatiya Sakshya Adhiniyam of 2023, the correct section is 160. Do not make a mistake with this section number in your exam. I'll say it again. It is now Section 160. All right, to wrap this all up and make sure it really sticks in your mind, let's do a super quick revision of the most important points you'll need for your exam prep. So here's a tip. For your prelims, you're probably going to see direct questions like, which section deals with impeaching a witness? For the mains exam, get ready for a problem-based question. They'll give you a scenario and ask you to explain how you challenge a witness's credibility using this exact section. So if you're in a hurry and need the key takeaways, just remember these 3 things. First, the section number is 160 of the Bharatiya Sakshya Adhiniyam. Second, its whole purpose, its core concept, is about challenging a witness's credibility. And third, the key principle behind it is that credible evidence is the foundation of justice, and courts need a way to filter out the unreliable stuff. So I'll leave you with a question to think about. How does giving lawyers this power to impeach a witness actually help protect the fundamental principle of a fair trial? It's a great question for your mains prep. For more content focused on your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Now, if you're gearing up for the judiciary or APO exams, you absolutely know how critical it is to master the new criminal laws. So today we're going to dive deep into one of the most practical sections out there, Section 159 of the brand new Bharatiya Sakshya Adhiniyam 2023. Let's get right into it. So here's our game plan for today. First, we'll tackle the core concept. Then we'll decode its essential parts, see it in action with some real-world examples, look at what the courts have said, compare it with the old law, which is super important, and we'll wrap up with some key tips just for your exams. Okay, let's start at the very beginning. What is Section 159 all about? Well, it's all about one key idea: corroboration. In simple terms, it's about how we can support or strengthen what a witness says in court to make it more believable. Now listen closely. This section is a huge deal for your judiciary and APO exams. Why? Because it's the rule book for checking if a witness is telling the truth. You see, it makes sure that evidence isn't just looked at in a vacuum. By linking a witness's statement to other things that were happening around the same time and place, it makes the evidence way more reliable. So now that we have the basic idea down, let's roll up our sleeves and decode the actual legal language from the BEAR Act. We're going to break it down into simple, easy-to-understand pieces so you can really get a handle on it. The most important part of this whole section is that a witness can be questioned as to any other circumstances which he observed at or near to the time or place. So what does all that legal jargon actually mean? Simple language में समझाए तो, when a witness is talking about a key fact, you can ask them about other little things that happened around that moment. This is exactly how you corroborate or back up their main story. In this section, there are a few key ingredients. First, you need a relevant fact. That's the main point the witness is talking about. Second, the whole reason for asking more questions has to be the intention to corroborate. Third, those questions have to be about surrounding circumstances, other stuff the witness saw or heard. And finally, and this is crucial, it's always up to the discretion of the court to decide if those extra details are actually relevant. This flowchart here just perfectly lays out the process. Step 1, the witness testifies. Step 2, the lawyer asks them about related stuff. And step 3, the court makes the final call on whether those details actually help prove the main testimony. See? It's a very logical flow that happens in court. Theory is great, but let's make this real. In this next part, we're going to look at some practical examples that are going to be super helpful for those problem-based questions you'll face in your mains exam. So, how does this actually play out in a real courtroom? How does a smart lawyer use Section 159 to build a stronger case? Let's take a look with a few clear illustrations. Okay, these examples really make it click. The first one is a classic, straight from the Act's own illustration. Imagine an accomplice is testifying about a robbery. If he also mentions some random things that happened on the way there, and you can prove those little things happened, it makes his main story about the robbery more believable. Same thing with a second example. If a witness says they were at a crime scene, but also stopped at a shop nearby, getting the shopkeeper to confirm that visit supports their presence. The bus ticket? It's the exact same logic. It's a small fact that backs up the bigger claim. All right, now let's talk about the judicial backbone of this section. How have our courts, especially the Supreme Court, looked at this idea of corroboration? This is essential for writing high-scoring answers in your mains exam. A landmark case you have to know is Rameshwar versus State of Rajasthan. Here, the Supreme Court laid down a very practical rule. It said that corroboration isn't a must-have in every single case. But, and this is the key part, when you do have it, it adds serious weight to the testimony, so its real value is in building a much stronger, more reliable case. And then there's another important one, State of Maharashtra versus Damu. In this case, the Supreme Court once again highlighted just how important corroborative evidence is, especially for the prosecution. It helps them weave together a chain of events that is consistent, logical, and ultimately much more believable to the judge. This whole concept is also deeply connected to a famous legal maxim called res geste, which literally means things done. It's about facts that are so intertwined with the main event that they are considered part of the same single transaction. Section 159 basically uses the same logic. It uses connected facts to paint a fuller, more credible picture. Okay, everyone, I really need your full attention for this next part. This is where a lot of students might get confused, and we want to make sure that doesn't happen to you in the exam hall. Let's compare the old law with the new one. Please pay very close attention and make a note of this. The provision we are discussing today was earlier Section 156 of the Indian Evidence Act, 1872. Under the new law, it is now Section 159 of the Bharatiya Sakshya Adhiniyam 2023. Do not make the mistake of writing the old section number in your exam. It's Section 159 of the BSA, not 156 of the old Act. This is a critical update you absolutely must remember. All right, we've covered the concept, the examples, and the case laws. Now let's get laser focused on exactly what you need to know for your exams. Think of this as your personal study guide for this section. For your prelims, you can expect very direct questions. They'll ask something like, which section of the BSA deals with corroboration? And you'll know the answer is Section 159. For the mains, it's a different ballgame. You'll probably get a problem-based question where you have to apply this section to a story. And no matter what you write, always remember to mention the key concept. The whole point of this section is to boost the credibility and reliability of a witness. So let's do one final, super quick revision. There are 3 things you have to walk away with. 1. The section number is 159 of the Bharatiya Sakshya Adhiniyam 2023. 2. The core concept is making testimony stronger with connected facts. And 3. This section is highly important for both your prelims and your mains.
And that wraps up our deep dive into Section 159. I really hope this breakdown was clear and helpful for your preparation. For more exam-focused legal content just like this, make sure you stay connected with us right here at Ganga Education.
Today, we're going to tackle a really important piece of the new Bharatiya Sakshya Adhiniyam 2023. We're talking about Section 160. Now, this section is all about corroborating a witness's testimony, which makes it an absolutely must-know topic for anyone prepping for judiciary and APO exams. So let's jump right in.
So here's our game plan for this explainer. We'll kick things off with the basics of Section 160. Then we'll break down its key components. After that, we'll look at some real-world examples and landmark court cases. And finally, we'll wrap it all up with a sharp focus on how to nail this topic in your exams.
All right, let's get started. Section 160 is located in Chapter X of the Bharatiya Sakshya Adhiniyam, the part that deals with how witnesses are examined. You know, its main job is to add strength and credibility to what a witness says in court. It's a tool to make their testimony more believable.
So why is this section so vital? Well, because in any trial, the big question is always, can we trust what this witness is saying? Section 160 gives us the legal pathway to support that trust. It provides a formal way to show that a witness is being truthful and consistent.
Okay, that's the BEAR Act language, and it can be a bit dense, right? Let's break it down into simple terms. All it's really saying is this. To support what a witness says in court, you can bring up a statement they made earlier. But, and this is a big but, there are a couple of conditions. First, that earlier statement has to be about the exact same fact. And second, it must have been made either right around the time the event happened, or it was made before a proper legal authority, like a police officer or a magistrate.
Now, for this section to actually apply in court, a few essential ingredients have to be there. Think of it like a checklist. Let's go through these components one by one to see how it all fits together.
First, and this is pretty obvious, the witness has to actually testify in court. Section 160 doesn't come into play otherwise. Second, there has to be a pre-existing former statement from that same witness. Third, that old statement must be about the very same fact they are talking about in court now. Fourth, the timing is crucial. It's got to be from around the time of the incident or recorded by a proper authority. And finally, and this is probably the most important point to remember for your exams, the purpose is only to corroborate. It backs up their credibility. It is not the main evidence itself.
Okay, so we've got the theory down, but how does this actually work in a real-life situation? Let's move from theory to practice with a clear example to see how Section 160 plays out in a courtroom.
So picture this. A witness sees a robbery and immediately goes to the police station and gives a detailed statement. Now fast forward 6 months to the trial. The same witness gets on the stand and describes the robbery again. At this point, the prosecution can bring up that initial police statement. Why? To show the judge and jury, look, this person's story hasn't changed. They said the exact same thing right after it happened. This shows consistency and makes their testimony much, much stronger.
And the legal idea behind all of this is super simple. Consistency strengthens credibility. It's just common sense, right? A person who tells the same story over and over is naturally seen as more reliable. Section 160 is basically the law putting its stamp of approval on this very human principle. So what do the courts have to say about this? Judicial interpretation is key to understanding the finer points. Let's look at how the higher courts, especially the Supreme Court, have viewed this provision.
The landmark case you absolutely have to know here is Tahsildar Singh versus State of Uttar Pradesh. In this case, the Supreme Court drew a very clear line in the sand. They explained that a former statement can be used in two ways. You can use it for contradiction, which is to show the witness is lying or confused, but you can also use it for corroboration, to show they are telling the truth. Section 160 is exclusively for that second purpose, to support, to corroborate.
Another key case is Rameshwar versus State of Rajasthan. This one added another important layer, reliability. The Supreme Court said, hold on, you can't just use any former statement. The court first has to be convinced that the statement itself is reliable and that it was made under trustworthy conditions. For example, it wasn't a statement that was forced out of someone.
Okay, now, Everyone preparing for exams, please pay very close attention. This is critical. Under the old law, the Indian Evidence Act of 1872, this provision was Section 157, but under the new law, the Bharatiya Sakshya Adhiniyam 2023, it is now Section 160. Do not make a mistake in your exams. The new law is in effect and you must cite Section 160. Got it? 160.
All right, let's zoom in and talk specifically about how you should approach this section for your exams. For your judiciary prelims, you can expect a very direct question, something like, which section deals with corroboration of a witness's testimony? The answer is Section 160. For the mains, it'll get more complex. You might get a problem-based question where you have to apply Section 160 to a hypothetical case. And remember that key point. Its value is only corroborative, not substantive evidence. Finally, in an interview, be ready to clearly explain the difference between corroboration and contradiction, and be sure to mention a case law or two.
So let's do a super quick revision. If you remember nothing else, remember these 3 things. First, the section number is 160 of the Bharatiya Sakshya Adhiniyam 2023. Second, its core job is to use a witness's own earlier statement to boost their credibility in court. And third, its legal value is only corroborative. It doesn't prove the fact itself.
And that's our deep dive into Section 160. I really hope this breakdown has made the concepts clear for you. For more legal explainers focused on judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Today, we're going to tackle a really crucial piece of our legal framework, how we actually evaluate evidence in court. We're going to do a deep dive into Section 161 of the brand new Bharatiya Sakshya Adhiniyam 2023. Now, if you're preparing for your judiciary or APO exams, you're going to want to pay close attention because this section deals with the real nitty-gritty of how evidence is tested for truthfulness. So let's get right into it. So here's our game plan for today. We're going to break down Section 16.1 into 6 easy-to-digest parts. We'll kick things off with a core rule. Then, we'll deconstruct the legal language to make it super simple. After that, we'll see this section in action with a practical example. We'll also look at the legal principles and landmark cases behind it and understand its real value. And of course, we'll wrap it all up with a quick revision session to get you exam ready. All right, let's start with the big idea. What problem is Section 161 actually trying to solve? Well, think about it. Once a statement, like a confession under Section 26 or a discovery statement under Section 27, is proved in court, what happens next? How do we know if it's actually true? That's where Section 161 steps in. Now, let's look at the language here. In simple terms, what this is saying is that once a statement under Section 26 or 27 gets proven, the court opens the door for more information. You can bring in other facts to either back up that statement, to corroborate it, or to challenge it, to contradict it. You can even bring evidence to test the credibility of the person who made the statement. It's like a toolkit for the court to examine a piece of evidence from every single angle. Okay, now let's get into the details and deconstruct this section. Breaking down the legal language is absolutely key for your mains exam. It'll help you write those sharp, clear answers that show you really understand the law, not just memorized it. So, what are the essential ingredients of Section 161? What are the building blocks that the court has to consider when this section comes into play? Let's take a look. This table really makes it clear there are 4 essential ingredients. First, the existence of a statement. You need to have a statement that's relevant under Section 26 or 27 to begin with. Second, that statement must be proved. It can't just be any statement, it has to be legally admitted in court as evidence. Third, and this is the core of it, further evidence is allowed. This opens up that toolkit we talked about, evidence to corroborate, contradict, or test the credibility of the person. And finally, there's the hypothetical test. This one sounds a bit complex, but it's simple, really. The law says you can bring in the same kind of evidence you would use if the person who made the statement was on the witness stand, being cross-examined and denying everything. It's a way to ensure a thorough check. And this chart here shows the logical flow perfectly. Step 1, a statement under Section 26 or 27 is proved. Step 2, this triggers the scrutiny under Section 161. Step 3, the court then allows more evidence to be admitted. And what's the whole point? Step 4, to test the truthfulness and credibility of that original statement. It's a really important procedural safeguard. Okay, we've covered the theory, but how does this actually work in a real courtroom? Let's move from the textbook to a practical scenario, because connecting theory to practice is what's going to help you nail those tricky problem-based questions in your exams.
Let's use a classic example involving a discovery statement. These statements under Section 27 are a hot topic in judiciary exams, so let's pay close attention to how Section 161 works with it. All right, let's walk through this scenario. Picture this: an accused person, let's call him A, is in police custody. He makes a statement: I have hidden the weapon used in the crime near the old bridge. Based on that info, the police go to the bridge and they find the weapon. At this very moment, the relevant part of his statement is considered proved under Section 27. But it doesn't stop there. Now, Section 161 kicks in. The prosecution can bring in a witness who says, yes, I saw A hanging around the old bridge that day. That's corroboration. On the flip side, the defense gets their chance too. They can bring evidence, maybe an alibi, showing A was miles away at that time. That's contradiction. See how it gives both sides a fair shot?
You know, to truly understand any law, you have to look at the why behind it, the legal principles, and the landmark cases that shaped it. So let's dig into the foundation of Section 161.
When we talk about this topic, one case is absolutely essential: Pulukuri Kothaya versus Emperor. This is a landmark judgment. What the court did here was clarify the scope of Section 27. It held that you can't just admit the entire confession. Only the specific part of the statement that directly leads to the discovery of a fact is admissible. This ruling is so important because it automatically creates the need for a provision like Section 161. If we're only admitting a small part of a statement, it becomes even more crucial to scrutinize it thoroughly. It's all about fairness.
And this idea of fairness that we see in the Pulukuri Kothaya case is actually based on a very old and very powerful legal maxim. The maxim is adi alteram partem. It literally means hear the other side. This is one of the pillars of natural justice. It's the soul of a fair trial. And Section 161 is basically this principle in action. It's the law saying, okay, we've heard this statement. Now let's hear what both sides have to say about it. This ensures that everyone gets a fair hearing. Okay, everyone, I need your full attention here. This is a crucial point for your exams, something you absolutely cannot get wrong. This provision isn't entirely new. It existed in the old law, the Indian Evidence Act of 1872, as Section 158. But now, under the new Bharatiya Sakshya Adhiniyam 2023, it is Section 161. Please make a note of this. Burn it into your memory. The old section was 158. The new section is 161. Do not make a mistake here.
So let's pull it all together. What is the actual value of this section? Why is it so vital for our justice system? Let's break down why it matters so much. The value of Section 161 is immense. First, it ensures that every statement is evaluated fairly and completely. The court doesn't just take it at face value. Second, it stops the court from blindly relying on confessions or discovery statements, which might not be the whole truth. Third, it opens the door for a complete 360-degree judicial review. And what's the result of all this? It dramatically enhances the overall reliability of the evidence that the court is considering. And that's the bottom line, isn't it? The ultimate goal of this section is to make the court better at its most important job, finding the truth. Section 61 is a powerful tool in that relentless pursuit of truth. All right, we're on the home stretch. Let's get to what is probably the most important part for all you aspirants, the quick revision. These are the key takeaways you absolutely must remember for your exams. So, are you ready? Let's do a quick recap of everything we've just covered. For your revision, lock in these 3 points. First, the section number. It is Section 161 of the Bharatiya Sakshya Adhiniyam 2023. I'll say it again, Section 161. Second, the core concept. In one line, this section allows more evidence to corroborate, contradict, or test the credit of the person who made a statement under Sections 26 or 27. And third, its exam importance. It is very high. For prelims, expect a direct question on the section number. For mains, be ready for a problem-based question where you have to apply its logic. And I'll leave you with a final thought to reflect on. How does Section 161 ensure that justice is not only done, but is also seen to be done? Think about it. It's all about transparency, opportunity, and the fundamental principle of a fair fight in the courtroom. For more such in-depth legal content focused on helping you clear your judiciary, APO, and law exams, make sure you stay connected with us here at Ganga Education.
आज हम डिस्कस करेंगे सेक्शन 162 ऑफ द भारतीय साक्ष्य अधिनियम 2023। ये सेक्शन डील करता है एक बहुत ही इंटरेस्टिंग कॉन्सेप्ट से जिसे कहते हैं रिफ्रेशिंग मेमोरी। Now for your judiciary and APO exams, this section is absolutely crucial. So let's dive right in.
So, here's our game plan for today. We'll start with a basic introduction to Section 162. Then, we'll break down its essential components. After that, we'll see how it works in a real courtroom, compare it to the old law, which is very important, understand the legal principles behind it, and finally, wrap up with some key revision points for your exams.
All right, let's start with the introduction. You know, it's just a simple fact of life that human memory isn't perfect. It fades over time. In court, getting accurate testimony is everything. But think about it. How can you expect a witness to remember every single detail of something that happened maybe months or even years ago?
Well, to tackle this exact problem, the law gives us a solution. Section 162. This section creates a legal pathway. It allows a witness, right there in the middle of their examination, to look at certain documents, like notes or a diary, to jog their memory. The whole point is to make sure that testimony they give is as accurate and reliable as possible. Okay, now for the important part. Let's really dig in and decode the essential ingredients of this section. These are the building blocks of this entire provision, and you absolutely need to have a clear understanding of them for your exams.
So this is the text directly from the act itself. Now, what does it mean in simple language? सिंपल भाषा में इसका मतलब है कि जब एक विटनेस कोर्ट में गवाही दे रहा हो, तब वो उस डॉक्यूमेंट को देख सकता है जो उसने खुद ट्रांजैक्शन के टाइम या उसके तुरंत बाद बनाया था.
As you can see in this table, there are 5 key elements here. First, this whole rule only kicks in when a witness is under examination. Second, they can refer to a writing, but it has to be one they either made themselves or one that someone else made, which they then checked and verified. Third, and this is critical, is the time requirement. The document must have been made contemporaneously, that is, at or very soon after the event. Fourth, copies can sometimes be used, but only if the court gives permission. And finally, there's a special rule for experts who can refresh their memory by looking at professional books or treatises. Let's quickly walk through how this happens in court. So, step 1, the witness is on the stand. Step 2, they ask to look at a document they made at the time of the incident. Step 3, the court will check the document's authenticity and the witness has to confirm that it's accurate. And only after all these checks and balances, in step 4, is their memory considered officially refreshed for the purpose of giving testimony. Theory is great, but let's see how this actually works in practice. We'll look at the real-world application of this section with a simple example and an important landmark case.
Let's take a very straightforward scenario. Imagine a witness saw a road accident. In court, a few months later, they can't quite remember the car's license plate number, but right after the accident, they had jotted it down in their diary. Under Section 162, the court can allow them to look at that diary entry to provide the correct number. It's as practical as that.
This isn't just theory. It's backed by our judiciary. In the landmark case of State of Gujarat v. Mohanlal Jitamalji Porwal, the court said something very important. It recognized that using documents to help a witness is a practical necessity to get to the truth. The court basically acknowledged that you can't always expect perfect human memory.
All right, everyone, I need your full attention here. This next part is extremely important, especially for all of you who are studying the new criminal laws. We need to compare this new section with the old one.
Please make a note of this. The concept of refreshing memory was earlier under Section 159 of the Indian Evidence Act of 1872. Now, it has been replaced and renumbered as Section 162 of the Bharatiya Sakshya Adhiniyam 2023. Don't make this mistake in your exams. The new section is 162 of the BSA, not 159 of the IEA.
You know, every law has a why, a core philosophy behind it. So what's the guiding principle that forms the foundation of Section 162? Let's take a look. The whole idea can be summed up in a simple, powerful maxim. Memory may fade, but records remain. It's a beautiful way of saying that while our memories can get blurry, a written record is permanent. And that's why the law places so much importance on documents that were created when the memory of the event was still fresh and clear.
Okay, let's shift gears now to the most critical part for all you aspirants, our exam-ready revision. These tips are designed to help you score those crucial marks in your judiciary and APO exams.
So, for your prelims, you can definitely expect a direct question on Section 162, or perhaps its key ingredients. They might even try to trick you by asking about the old section number, 159 of the IAA. Now, for your mains exam, be ready for a problem-based question. They might give you a scenario with a witness and a document and ask you to apply the law. A short note on refreshing memory is also a very common question.
For a super fast revision, just lock these 3 things in your mind. First, the section number. It's Section 162 of the BSA 2023.
Second, the core concept, it's all about refreshing memory using a document made at the time of the event. And third, exam importance, it is extremely high for both your prelims and your mains.
And finally, as we wrap up, I want to leave you with a question to think about. If a witness can refer to notes, how does the court make sure this doesn't turn into an opportunity for them to give false or fabricated testimony? Think about the safeguards that are built into this process.
For more such exam-focused legal content for your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.